Claire Reed. We have seen that criminal law primarily protects the interests of society, and civil law protects the interest of the individual. The primary purpose or function of criminal law is to help maintain social order and stability. The Texas Criminal Code proclaims that the purpose of criminal law is to establish a system of prohibitions, penalties, and correctional measures to deal with conduct that unjustifiably and inexcusably causes or threatens harm to those individuals or public interests for which state protection is appropriate. The New York Criminal Code sets out the basic purposes of criminal law as follows. Harm. To prohibit conduct that unjustifiably or inexcusably causes or threatens substantial harm to an individual as well as society. Warning. To warn people both of conduct that is subject to criminal punishment and the severity of the punishment. Definition. To define the act and intent that is required for each offense. Seriousness. To distinguish between serious and minor offenses and to assign the appropriate punishments. Punishment. To impose punishments that satisfy the demands for revenge, rehabilitation, and deterrence of future crimes. Victims. To ensure that the victim's family, and the community interest are represented at a trial and imposing punishments. The next step is to understand the characteristics of a criminal act. Principles of criminal law. The study of substantive criminal law involves an analysis of the definition of specific crimes and the general principles that apply to all crimes, such as the defense of insanity. In our study, we will first review the general part of criminal law and then look at specific offenses. Substantive criminal law is distinguished from criminal procedure. Criminal procedure involves a study of legal standards governing the detention, investigation, and prosecution of a crime and includes areas such as interrogations, search and seizure, wiretapping, and the trial process. Criminal procedure is concerned with how the law is enforced. Criminal law involves what law is enforced. Professors Jerome Hall and Wayne R. LaFever identify the basic principles that compose the general part of the criminal law. Think of the general part of the criminal law as building blocks that are used to construct specific offenses such as rape, robbery, murder. Criminal act. A crime involves an act or failure to act. You cannot be punished for thoughts. A criminal act is called actus reus. Criminal intent. A crime requires a criminal intent or mens rea. Criminal punishment is not ordinarily directed at individuals who intentionally, knowingly, recklessly, or negligently harm other individuals or property. Concurrence. The criminal act and criminal intent must coexist or accompany one another. Causation. The defendant's act must cause the harm required for criminal guilt, death in the case of homicide, and burning of a home or other structure in the case of arson. Responsibility. Individuals must receive reasonable notice of the acts that are criminal so as to make a decision to obey or to violate the law. In other words, the required criminal act and criminal intent must be clearly stated in a statute. This concept was captured by the Latin phrase "Nullum crimen sine lege, nulla poena sine lege." No crime without law, no punishment without law. Defenses. Criminal guilt is not imposed by an individual who is able to demonstrate that his or her criminal act is justified, benefits society, or excused. The individual suffered from a disability that prevented him or her from forming criminal intent. We now turn to a specific part of criminal law to understand the various types of acts that are punished as crimes. Categories of crimes. Felonies and misdemeanors. There are a number of approaches to categorize crimes. The most significant distinction is between a felony and a misdemeanor. A crime punishable by death or by imprisonment for more than 1 year is a felony. Misdemeanors are crimes punishable by less than a year in prison. Note that whether a conviction is for a felony or a misdemeanor, it is determined by the punishment provided in the statute under which an individual convicted rather than by the actual punishment imposed. Many states subdivide felonies and misdemeanors into several classes or degrees to the death penalty or life in prison in states that do not have the death penalty. The term gross misdemeanor is used in some states to refer to crimes subject to between 6 and 12 months in prison, whereas other misdemeanors are termed petty misdemeanors. Several states designate a third category of crimes that are termed violations or infractions. These tend to be acts that cause only modest social harm and carry fines. These offenses are considered so minor that imprisonment is prohibited. This includes violation of traffic regulations. Florida classifies offenses such as felonies, misdemeanors, or non-criminal violations. Non-criminal violations are primarily punishable by a fine or forfeiture of property. The following list shows the categories of felonies and misdemeanors and the maximum punishment generally allowable under Florida law. Capital felony, death or life imprisonment without parole. Life felony, life in prison and a $15,000 fine. Felony in the first degree, 30 years in prison and a $10,000 fine. Felony in the second degree, 15 years in prison and a $10,000 fine. Felony in the third degree, 5 years in prison and a $5,000 fine. Misdemeanor in the first degree, 1 year in prison and a $1,000 fine. Misdemeanor in the second degree, 60 days in prison and a $500 fine. The severity of the punishment imposed is based on the seriousness of the particular offense. Florida, for example, punishes as a second-degree felony the recruitment of an individual for prosecution. This is the same act punishable as a first-degree felony in the event that the person recruited is under 14 years old or if death results. Another approach is to classify crime by moral turpitude. Mala and say crimes are considered inherently evil and would be evil even if not prohibited by the law. This includes murder, rape, robbery, burglary, larceny, and arson. Mala prohibita, offenses that are not inherently evil, are considered wrong because they are prohibited by the statute. This includes offenses ranging from tax evasion to carrying a concealed weapon, leaving the scene of an accident, and being drunk and disorderly in public. Why should we be concerned with classification schemes? A felony conviction can prevent you from being licensed to practice various professions, bar you from being admitted to the armed forces or joining the police, and prevent you from adopting a child or receiving various forms of federal assistance. In some states, a convicted felon is still prohibited from voting even following the release. The distinction between mala in se and mala prohibita is also important. For instance, the law provides that individuals convicted of a crime of moral turpitude may be deported from the United States. There are a number of other classification schemes. The law originally categorized as infamous, and those crimes were considered to be deserving of shame or disgrace. Individuals convicted of infamous offenses such as treason or offenses involving dishonesty were historically prohibited from appearing as a witness on trial. This textbook is organized in accordance to the subject matter of crimes, the scene that is followed in most state criminal codes. There is disagreement, however, concerning the classification of crimes. Robbery, for instance, involves the theft of property as well as the threat of infliction or harm on the victim, and there is debate about whether it should be considered a crime against property or a crime against a person. Similar issues arise in regards to burglary. Subject matter offenses in descending order of seriousness are followed: crimes against the state, treason, sedition, espionage, and terrorism; crimes against a person, homicide, murder, manslaughter; crimes against the person, sexual offenses, other crimes, rape, assault, and battery; crimes against habitation, burglary, arson, trespassing; crimes against property, larceny, embezzlement, false pretenses, receiving stolen property;